Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Now, before I get started with this podcast, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this. And now that I've said it, nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Today, we're going to take a deep dive into one of the most misunderstood but absolutely critical distinctions in a disability insurance policy or plan. It's the difference between own occupation and any occupation. Now, if you've ever tried to make sense of a long-term disability policy or plan, or you've had to file a claim yourself, you probably have come across these terms. They sound straightforward, but the implications are anything but. The definition in your policy can mean the difference between receiving benefits when you're no longer able to work in your specialized profession, or being denied because the carrier thinks you can do some other job, even if it's so far outside of your expertise that it's almost silly, or it pays significantly less than what you were making at the time you became disabled. So in today's episode, I'm going to break down exactly what these terms mean and why they matter. I'm going to talk about three things. One, your own occupation versus any occupation. What's the difference? Two, the secret to getting your own occupation or risk of disability benefits. Number three, tips for preventing a denial of your own occupation psychiatric disability insurance claim. Got it? Let's take a break for a moment before we get started.
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Own occupation versus any occupation. What's the difference? Well, there's a huge difference. When you file your disability insurance claim, your ability to qualify and receive benefits really depends on how your policy defines the term disability. There are two major types of definitions in a disability policy or plan. There's own occupation and any occupation. Now, they sound similar. Occupation, the only difference, right, is own or any, but that's not quite. Own occupation refers to your inability to perform the specific occupation you were doing at the time you became disabled. Remember, you didn't insure a job, you insured an occupation. And so if you're a surgeon, for example, and you can't stand for long periods of time or do intricate procedures due to a physical condition, you could qualify if you have an own occupation subspecialty policy. Now, you might also have just a pure own occupation policy, which can be defined as the inability to do the material and substantial duties of your own occupation, or the inability to do the important duties of your occupation, or any other variation of that particular definition. There's just not one definition of any occupation. So before going into this claim, you need to understand that. Now, what will, of course, happen in most disability policies or plans, except for generally IDI claims, individual disability insurance, you will say that after 1, 2, or 3 years, there is a change in the definition from an inability to do your own occupation to an inability to do any occupation. Now, what does that mean? I got to get that disability policy or plan out. But generally what it means is that you have to be unable to perform any job for which you are, any occupation for which you are reasonably qualified by education, training, or experience. Not just your occupation, but any occupation, even potentially if it pays less. And again, that's going to depend on the terms of your policy. Now, here's the catch. Many ERISA-governed employer policies start with the own occupation definition, but then switch, and normally it's 24 months. Now, what's important about that is there's going to be a transition investigation, guaranteed, okay? And by the way, disability carriers or plans require that you apply for Social Security disability benefits. And just about the time you might be getting your Social Security disability benefits, the definition of disability changes to any occupation benefit. And I'm going to talk about the interaction and how you can be whipsawed with that occurrence. Now, I will tell you the transition point from own occupation to any occupation is where carriers and plans are going to ramp up the scrutiny of your claim. What are they going to do? Well, about 6 months before this definition changes, they may send you a letter that says, hey, just remember the definition of disability changes. If the light bulb hasn't gone on before, the light bulb should be going on in your head right now. Why? What they will be doing is multifactorial. They are going to send you a updated activity of daily living form for you to report on. They may ask you to update your vocational profile, your educational history, your licensure history, current licenses that you have. They may ask you to also give them one of your old resumes. They may ask you for a description of your occupational duties. Why? What they're trying to figure out with all of that is, one, ultimately, they're going to have their doctors review your medical records and come up with their assessment of your restrictions, limitations. They want to be able to argue that you're capable of engaging in sedentary work, which is basically sitting 6 out of 8 hours, lifting no more than 10 pounds. And what they then want to do is to look at that vocational history, what your occupation was, the training, the experience that you have, to determine whether you have any skills that you have learned from your occupation that you could take from your own occupation to any occupation. Now, to help them do that, they may schedule you with a not so independent medical evaluator or a not so independent functional capacity evaluator. Whether or not they have the right to do that depends on the terms of your policy or plan. And if you are told that you need a report for an IME or an FCE, you need to hire a lawyer immediately to learn about the protections that are crucial to protect you at that stage of the case. They will put surveillance on you. And before they do that, however, they're going to do a social media check. So please, if you haven't, don't ever do social media if you are on long-term disability. They're going to check. I see it all the time in claims files where they'll hire a private investigator rather, to investigate you. They'll do address checks. They'll look for where you live. They will look for who lives with you. They'll look at what cars you own. They will look at your criminal background, your licensure background. They're going to do a social media search. They may even reach out to you to take a statement from you. And that's not necessarily a social call. So again, if before the definition of disability changes from any occupation to own occupation and you're getting that call, tell them to put their questions in writing because, again, it's going to be a setup. They're looking for inconsistencies that their doctors can use or they can take back to your doctor to say, oh, you can really do some kind of a sedentary work. Now, again, understanding that policy is crucial. You have to look for definitions. You have to understand when things change in the policy because the burden of proving that you're disabled gets much higher, and you have the burden of proving that. Now, in the next section, I'm going to talk about qualifying for own occupation benefits and that sedentary work that I alluded to. All right.